going to do the wonderful recipient rights, confidentiality, and HIPAA training today. We will also be doing the whistleblowers, the LEP, and fraud training. So, I'm going to try and go through this quickly. It's not going, Kenyon. Okay. Recipient rights will be first. The recipient rights advisor's main duty is to monitor our services, investigate complaints that are made by anybody, clients basically, and provide you guys with training on a yearly basis. The rights advisor has to have access to all evidence to investigate and protect the rights of the persons receiving services for our agency. Filing a recipient rights complaint with the advisor is from the client. Normally, we as employees don't file a complaint with me. If you have an issue with something that's going on at the agency, you need to talk to your supervisor. The client, I have 5 days to acknowledge that I got it from the client. And it may or may not need an investigation because I can do a informal process to find out, because sometimes people just want somebody to know what happened. They don't really want to fill out a form and file a formal complaint. They just call and talk to me, and I document what was said, and I talk to the supervisor of the staff person, and they work it out with the staff person, the issue that they have with the client. If I do have to investigate, there are specific dates and times that I have to reply to different things. Consumers must be told that he or she has a right to when they're receiving services. All of our consumers sign a consent up front. We hand them their HIPAA rights paperwork and the information packet that we have for our agency itself, which tells them that I am the recipient rights person and that's who they contact if they have an issue. Consumers need to be competent to make their own decisions. They can have guardians that would sign the paperwork for them. We need to treat them with dignity and respect. And I just say that means you should treat them the same way you would like to be treated. Clients have the right for not to be abused or neglected. And if you have anybody that you feel is abused or neglected, you need to do your proper procedures. File an incident report, notify your supervisor, and notify the authority above us, which whoever we contract with. Your program is under DHS, the state of Michigan, Mission, all of those. And the mental health code requires that employees report suspected criminal abuse also. Clients have the right to confidentiality, and we will go over that more in detail. Information can be released if it's court order, signed by a judge, the guardian of a client, needed information to get benefits for reimbursement. So if we are billing Blue Cross and they want more information, the clients actually sign an authorization sheet when they start their services with us that we can release some of their information in order for us to get paid. If a client threatens themselves or someone else verbally, you are mandated to report that. Consumers have the right to see their records upon request. There is a legitimate time frame that we have in our policies that we can take to make sure the file's in order before we actually give them copies of it, and or we usually go over it with them. We don't just hand them the whole file, a copy of it. Consumers have the right to receive services in a place that is safe and clean, and people who receive services have the same civil rights as everyone else. Clients have the right for centered planning. There are 4 basic parts: identifying the future the consumer desires, planning the future, finding support, and getting feedback on their treatment. Incident reporting. Our agency has a policy on incident reporting. We've been over it with you guys. We have new forms that you can fill out on the computer. If you do not have them, please contact Sarah Sabin. She will make sure that you can have the original. What are you shaking your head no for? She will make sure you have the proper form to fill out. You must fill it out as soon as possible. Do not wait. Make sure you follow the guidelines on the form and make sure a copy goes to your supervisor, the CEO, and any other supervisor that is involved in the incident. And if you are in any kind of doubt of whether you should fill one out, ask. But my philosophy is, if you're in doubt, fill one out. It doesn't hurt to do it. It's not gonna hurt anybody. It's just gonna be investigated, and if it's not gonna hurt anything, you're just told that. Thanks for the information, okay? You must be clear, complete, concise, and timely with it. And like I said, when in doubt, fill one out. And if you are in doubt, you can ask Sarah, you can ask me, you can ask Deja. We all know, your supervisor should know that when you should fill one out. They've all had trainings on this stuff. Here are some events that would require a completion of an incident report. Any injury, medical problems, seizure, an accident, if someone falls in the parking lot. Even if it's one of our own employees, fill out an incident report. It doesn't have to be just a client. Okay? Consumer to consumer aggression is another one. Suspected criminal offense. Death. Law enforcement involvement. Inappropriate sexual conduct. That's a big one going on around the world right now. Known suspected violation of rights and safety issues. Incident reports are means by which any unusual event in a consumer or a employee's life is reported in a uniform way, but the employee thing has to happen during work hours. If you're at a home doing a visit during your work and you have an incident, fill one out. It doesn't have to be on site. It just has to be during your work hours. Okay? Any questions on that? Oh, onward to confidentiality of alcohol, drug, and mental health treatment. What is a right? When we talk about rights, we mean something that an individual or a class of individuals is guaranteed by law. A right falls under these categories. Something an individual can do by law: freedom to, freedom of, the right to vote, freedom of speech. Something an individual can have or receive: entitlements, protection under law, freedom from, the example, freedom, the right to freedom from abuse. We don't want to abuse our clients verbally, physically, any of that type. Violating this, $500 fine the first offense, up to $5,000 for each time after. The drug and alcohol program may lose its state certification, and then we can't have that program anymore. Medical professionals can lose their licenses. A program may not disclose any information that would identify a patient. So, if you are sitting around talking to your coworker and you're talking about a client, just make sure it's not a bunch of people standing around listening to what you're saying. If you are outside the agency in a restaurant, sitting down at the park eating your lunch, meeting for coffee somewhere, waiting for a training to start and you're with a coworker, don't sit there and talk about what's going on with your clients, especially anything that has to do with their services, because somebody else could know that client. Whether you think it's strange that that'll happen, it could happen. They could realize who you're talking about just because they know of some instances about that person. Okay? So if you're going to talk about clients, only do it in the agency and only with the people that need to know. patient identifying information, that's basically the same thing as their file. Anything that identifies them. Their social security, their date of birth, you know, their name. We try to use different codes for their names in some of our systems so they're hard to detect. One identifying factor, I've worked with Born Free on this before with their Google Calendar. Hopefully we'll be off of that soon. We've set up a plan where we use the first 2 letters of their first name and then the first 4 letters of their last name and combine that. So it's kind of like a code, so they don't know who that person would be, okay? Because in my opinion, you can identify somebody by their last name. You can identify somebody by their first name, just by coincidence. Handling written records with patient's name without proper releases, that's handled mostly by Tony. If somebody files a request for paperwork, that all goes through Tony in the front office, and she makes sure that the paper that they're requesting goes out and that we have authorization to do that. If you're sending out a letter, yes, Sarah.
I just have a question about that. So if a client says, hey, can I get a copy of my treatment plan, or hey, can I get a...
Oh no, not the regular stuff. If it's a request
letter
for something that is massive, like they want a copy of their progress note, all their progress notes. They don't just want what you just completed with them. That you can do, as long as you're releasing it to them directly. Mostly what Tony handles is court order releases, subpoena releases, Social Security determination releases, and that kind of stuff. If a client does come in and want their whole file, that does go to Tony. But if you're just releasing their treatment plan that you just wrote up for them and they signed off on, you can give them that. It is theirs to take. If you're sending something out in the mail, please make sure you use just the P.O. Box return labels. Do not put our full address on them. That identifies the possibility that they're coming here for treatment or for some reason, and they may not want somebody to know that. We do have clients that come in and say, please do not call my home. Please do not leave a message at my home, because they don't want anyone in their family knowing they're coming here. And we have to abide by that. A patient is anyone who has applied for or received any sort of individual or group services, treatment, counseling, or a diagnosis. A person who schedules an appointment for an evaluation but never shows up is considered a client. A person who completes an intake but does not enter treatment is considered a client. A person who receives services but did not ask for them is still a client. But if a person's appointment was arranged by someone else, they are not our client. If they do not show up, we don't have to recognize them as a client, because they didn't set it up. Say a probation agent calls and says they want us to see so-and-so, blah, blah, blah. Usually we tell them they need to call or we need to talk to them. But in the past we've had this happen, and if the client never shows, they aren't considered our client. But if they call themselves, we have to acknowledge them as a client and treat their confidentiality as it should be. Minors have rights. Minors the age of 14 years or older may receive certain services here at our agency, except for medication and family planning services, for a certain period of time. And our agency's policy is 4 visits, and that is without parental notice, too. Information can be disclosed within the program, like I was saying, to people that need to know, okay? If they need it. Say the billing department needs to, Cassie needs to verify that a client came in for a service that she's billing. She can go look at that client's file and make sure there's a progress note, because a progress note is, I call it like the Bible. That's a page in the Bible. That's what it is. That's when they come and audit us, an insurance company. If that progress note isn't there, they're going to take that money back. So it has to be there. That is what is the real thing. Okay. A counselor can share information with their clinical supervisor and members of the clinical team, and they cannot, though, distribute lists of their clients to all the employees unless they have a need for it. The only people that I know of that have a need to know who all is a client here are Tony for information in the front, and checking and verifying insurances for Cassie, and Medicaid. Tony has a list of Medicaid clients that she verifies every month. But other than that, that doesn't get shared with people. It's just for their job purpose. Remember, anyone within the program or an indirect administrative control of it who receives information under this exception is bound to confidentiality. So, everybody is bound to the confidentiality in this agency for all of our clients that we serve. So if you find out information, then you just need to keep it quiet. I know one of the trainings that we give our front office staff is if someone walks into the building, especially if they have an outside job, if someone walks into the building or they walk into their other work and they're a client here, they cannot acknowledge that client until that client acknowledges them. And if they never do, you can't. I had a cousin that came, my husband's cousin came in here for years when I was working back up to the front desk. And she never acknowledged that she knew me. Not one time she came in. So I could never say, oh, hey, hi, how you doing? How's your mom and dad? You know, and that kind of stuff. I never could do that because she would not acknowledge that she knew me. Consent. A program may disclose information about a patient if a patient specifically authorizes the process by signing a valid consent, which is we call an authorization to release information. Who can disclose patient identifying information is what it must include. Whom, the name of the patient, the purpose for the disclosure, and information being disclosed. And we should, on those, write what we're going to send out. The client should say, I need you to send all the progress notes, or I just need my treatment plan sent to my doctor, so that they know what's going on and why I should be taking these meds. And we contact PCPs. We have authorization to release information to PCPs for our mental health clients and our substance abuse clients, so that they can communicate with them. And that's what the new thing is everybody's insurance and information is out there, so the communication is there, so people are being treated for things the way they should be. Not that this doctor doesn't know what that doctor's doing, because they have all these specialties now for everything. There are limited exceptions to when confidentiality can be voided without consent. You know, you can say something without consent. There's an emergent situation, reporting child abuse and neglect. But you can only report stuff that needs to be reported. You can't exaggerate on it, especially to the medical people that are coming in. If a client poses an immediate threat to the health of an individual, or there's a medical intervention that needs to be done right away. You can only disclose to medical personnel, like I said, those that need the information. If a family member's here, unless you have a release to say anything to them and they're sitting in the lobby, you can't tell them anything that's going on. Program staff must comply with the state mandatory reporting laws per the following. Make an initial report to the state child abuse hotline and submit the form that you would fill out, the 3200. Although HIPAA allows ample disclosure to law enforcement agencies, these provisions are permissive and not mandatory. And whereas 42 CFR, which is mostly for substance abuse clients, not the mental health side, there's a limit to when such disclosures can be allowed. Programs should continue to follow the 42 CFR because it's more stringent for for that than the mental health side for reporting. Oh, it's the same thing. As you work with patients, remember to practice confidentiality no matter where you are. Like I said, be careful of your surroundings. We are all responsible for practicing confidentiality, and it is the patient's right that we do so. Now we're into HIPAA. HIPAA goals. HIPAA was created to simplify the administration of health insurance claims and lower costs, and give patients more control and access to their medical information. Protect individual identifiable medical information from real or potential threats of disclosure or loss. Patients have the right over the use and disclosure of his or her own personal health information, and they determine who or how that information is shared. Specific measures are taken for security reasons because most of the HIPAA stuff is online now. Hopefully our agency will be becoming a medically EHR, EMR, what do I want to say? The electronic medical records, there we go. Yeah, EMR. Security measures must be put into place to protect that information. And we are working on that with our advanced MD, and we are looking to get Born Free and all the clinical staff up online, at least with the scheduling here in the next few months. And then we're gonna start doing progress notes and other paperwork in that system. So that'll be a new process for everybody in the substance abuse and mental health realm. We're gonna also try and get people that see clients up on the scheduling too, so that their clients are all in one, everybody's schedule is all in one area for clients. PHI, which is protected health information. Basically, we discussed a lot of this in the recipient rights area where you're protecting your client's information. How you transmit it paperly, electronically, or verbally. Use reasonable and appropriate as your guide. We always honor clients' confidentiality. Under HIPAA security regulations, this principle is extended to include the physical office environment, office staff, and computer equipment and software. So we have Kenyon make sure that the laptops that you guys are on have a little bit more security than your general laptop at home. So you shouldn't be using your general laptop at home to do any kind of client work on. There are four main areas of safeguards, and one is record storage. All clients' files are stored in lockable file cabinets. Open cases in the file room and closed cases in the back storage area. And they are all double locked, as you all know, when we are not here. The file room is open for you in the front when you are here to do work hours. Client files should never be locked in a therapist's office or taken out of the building without proper permission, and the only person that can allow that to happen is Bob Howell. So do not ever walk out of this agency with a client file without him knowing that. You can fax. Fax and copy machine areas are unmanned, and that's bad because if you don't go get your paperwork that you print that might have client information on it back in the copier area by the bathrooms, because our clientele now use that bathroom back there, you should make sure you get that paperwork out of there ASAP. Don't leave it sit, because they could, curious minds want to know. So don't leave it sit there for any period of time. Have your computer screens automatically time out, and then you have to sign in to get them back up. That's another protection that we can use so that other people can't view it. You can't have your computer facing the doorway so people as they walk by can see what you're working on and that kind of stuff. That's another protected area that I try and watch when people are rearranging their offices. Like Cindy just rearranged hers, and I walked by it the other day and made sure that her computer screen wasn't visible by the door.
Don't leave passwords laying around
do also occasionally walk around for people that do store client files in their office and double make sure that they're locked in their file cabinets. Because I usually get here before everybody else does. Or I come in on Saturdays occasionally and work, and I'll walk around the building and open doors and check to make sure that your file cabinets are locked up. When communicating electronically versus email, electronic calendars, text is not a good thing. Don't talk to your clients through texts. You don't know that your side may be protected. You may have had Kenyon check your phone and say, okay, yeah, I can do this with but their side may not. So they don't know that. So you should make sure that you don't use texting. Our agency doesn't really like that at all. And like I said, do the one-factor identifying information. First name or last name, not both. Clients, 4 digits of their social security number, not the whole social security number, that kind of stuff. Proper electronic security are in place, and all staff and any affiliates are aware of protecting our clients' PHI. So all of our affiliates know, and they sign an agreement with us too, in order to make sure that our information is kept private and confidential for our clients. Verbally, when you discuss a client's PHI, staff should be well aware of their surroundings, like I've talked about, just reiterating under the HIPAA. And it does say here that HIPAA does not specifically address cell phone use, but there could be that incidental disclosure. Whenever possible, don't use your cell phone. And here's the text message and emails on your cell phone. Like I said, their side may not be protected, even though ours is.
One exception being Tracy, because she is using an agency phone to have direct contact with clients.
But if she's sending them in, she can call them off of that, and they can call her back. But she shouldn't be sending text messages that identify them as a client in treatment. In conclusion, there are some ways we are protecting the personal health information we are responsible for. These are some ways. The standards have been set, and we need to follow those practices. Thank you. Any discussions?
Sean has a really good joke.
Okay.
It's super appropriate for this.
Okay, great. Sounds great. Go for it.
Sarah, knock knock. Who's there? HIPAA. HIPAA who? I can't tell you that.
That was perfect.